Hello, I'm Rachel McCallum, the New South Wales Information Commissioner. Under the Government Information Public Access Act 2009, or GIPA Act, members of the public can seek an external review by the Information Commissioner of a formal access application decision made by a public sector agency. Officers of the Information and Privacy Commission support both the Information Commissioner and the Privacy Commissioner to undertake their statutory review functions. The purpose of this short explainer video is to provide insight about the IPC's external review functions for information access to help individual public sector practitioners and agencies understand the process better. The object of the GIPA Act is to maintain and advance a system of responsible and representative democratic government that is open, accountable, fair and effective. The IPC promotes transparency, champions legal rights to access information and assists New South Wales Agency to fulfil their obligations. As part of our functions, we are authorised to review some GIPA decisions made by agencies. An important part of the Information Commissioner's integrity function is also to educate public sector duty holders. The IPC's review outcomes usually include guidance, therefore, as well as more formal findings and recommendations for agencies. In a recent report on the operation of the GIPA Act, 46% of reviews by the Information Commissioner recommended that agencies reconsider their decisions. Of those, however, 33% of internal reviews by agencies that followed arrived at the same decision as the original one. This explainer will hopefully help to bring those two statistics into greater alignment in the future. Under the GIPA Act, the Information Commissioner must complete a review and make any recommendations to the agency within 40 working days after the Information Commissioner receives all the information they consider necessary to complete the review. This timeframe means that the IPC must adopt quite a formal approach to running external reviews. It is not mandatory in New South Wales for a person to seek a review by the IPC before seeking a full merits review by the New South Wales Civil and Administrative Tribunal. A GIPA applicant is entitled to go directly to the NCAT within 40 days of receiving the agency's GIPA determination. A GIPA applicant can also seek internal review by the agency itself, but it's not mandatory to do so. If a GIPA applicant decides they do want the IPC to review an agency decision, there are a few key steps that will take place. I will set those out one by one in a summary form. If a GIPA applicant does decide they wish to have an external review by the IPC notifies the agency they have received the review application and provides them with a reference number. The IPC then undertakes a preliminary assessment to identify key issues to be examined and allocates the application to a review officer. The review officer is a delegate of the Information Commissioner and liaises with the agency to seek any specific information that may be needed. Agencies are required to share information with the IPC upon request unless a legal exception applies. Under Section 97 of the GIPA Act, it is an agency's responsibility to justify its GIPA decision to the IPC. When we request material supporting your decision, therefore, please ensure that your response is thorough and includes any additional submissions you think are necessary to justify the original decision. This will help avoid the need for the Information Commissioner to follow up for further clarification. We generally require agencies to provide the information needed for the IPC to review their decision within 5 working days. However, we do understand that exceptional circumstances may arise. Should you require an extension, please contact us with the reference number and provide an explanation. It is important that we are informed of the reason for any extension request. In most situations, the review officer will go on then to analyse the material provided and will come to a view about whether the reviewable decision has been justified within the 40 working day review period. The review officer will look at a range of factors, including the process that the agency followed and the agency's decision itself, to help them form a view about whether the agency correctly followed and applied the provisions of the GIPA Act. Within this process, we may ask you more questions if needed, and we may speak with the applicant also. We may also look at any relevant case law that may apply to your circumstances. During a review, the IPC has a statutory obligation not to disclose information that is subject to an overriding public interest against disclosure or a claimed one. The IPC does treat its confidentiality obligations seriously during the review process. Typically, the review officer's draft final report will include a recommendation for reconsideration where the agency's decision has not been justified. In a case where the reviewable decision has been justified, the officer may decide to make no recommendation. Once the review officer has drafted their review report, it undergoes quality assurance by senior IPC staff. A final review report is then issued to both parties. The IPC expects confirmation of whether an agency has accepted the recommendations within 10 working days. If an agency decides to accept a recommendation to reconsider a GIPA determination, a new agency decision must be made as if it was internal review. If an access applicant is still dissatisfied with the agency's approach after a review by the Information Commissioner, they can still apply to the NCAT for a full merits review of the agency's decision. That application must be made to NCAT within 20 working days of notice of the Information Commissioner's review outcome, assuming the agency does not go on to undertake an internal review first. Review reports from the IPC are not themselves administratively reviewable by the NCAT. The Commissioner may decide later, however, to participate in any NCAT proceedings brought by the access applicant. This statutory right of appearance is exercised to assist the NCAT around the objectives of the GIPA Act and the application of the law, rather than to support either side in the review proceedings. In closing, the IPC recognises the considerable effort and resources that can be involved in agencies undertaking an assessment, reviewing files, completing the public interest balancing exercise, and communicating with the applicant. For the sake of both good governance and transparency around public sector decision-making, however, agencies should be open to revisiting their decision if the IPC makes a recommendation to do so. The IPC also has lots of detailed information on its website about the legal and policy frameworks that apply to information access in the New South Wales public sector. I would encourage you all to familiarise yourselves with that material and also to contact the IPC by telephone or email if you would like further guidance about your agency's obligations. Thank you.